Southwest Topeka has a good neighbor. State Farm agent Jim Garrison, now at 29th and Urish. If your current insurance situation has you going around in circles, get off the roundabout and stop in and meet Jim and his wonderfully efficient staff. Let Jim Garrison give you a quote and make the Garrison comparison. He's confident that with State Farm's competitive rates, the right coverage, and his unmatched service, you'll want to make him your new insurance agent. Like a good neighbor, State Farm is there, and Jim Garrison is there for you, northeast of the roundabout at 29th and Urish.
When someone has a passion for what they do, it comes through in the product they provide their customers. Just ask LaRocco's Pizza's new owner, Jason Johnson, about their crust. They make it every day and let it rise for a minimum of 24 hours before they use it for their pizza. And his staff doesn't want to do anything they won't be the best at, and you can taste it in their pizza. LaRocco's Pizza, just a half block north of the I-470 and Gage Boulevard exit. Come taste the difference.
It's time for Real Estate 101 with the Carrie Brown team from Preferred Advisors.
Good Saturday morning to you. This is Carrie Brown with eXp Realty, and you're listening to Real Estate 101. I am here with the infamous Vern Jarboe from Sloan Law Firm. Good morning, Vern.
Good morning, Carrie.
We are going to be talking about wills, trust, estate planning, mistakes, things to avoid, and things to do just right the first time.
Okay.
So when it comes to estate planning, is that relevant for everyone?
Well, certainly there's some people that would derive very little benefit for spending a lot of time in estate planning. But if you think about the really big picture, you'd say, well, anyone with children should give consideration to it. Anyone with assets that they care about after they're gone should consider estate planning. And that probably would be the two big categories, because if you have children and you don't plan for their care should something happen to you, then something will likely happen to you, and your children will be left to whatever some judge thinks should be done. By the same token, if you don't deal with estate planning and you have assets, then the state of Kansas has written a will for you, and that will basically says that half of everything you have goes to your spouse and the other half goes to your children. So, Carrie, you and I are not married, but let's assume that we were, and that we both had a previous marriage, and we had children by previous marriages, and then we did our estate planning like some people do, which is you put everything in both names, so cars, houses, bank accounts, and then I die first. And we always know that's going to happen because the guys always die first. So then I die first, you have everything because we titled it that way. And because you have everything and then you die second, then your children would get everything. And that's probably not what most people would want. It may be what you want, but if you don't like the state of Kansas controlling what happens to your assets, then estate planning would be a good idea.
So in other words, your kids would have gotten left out.
My children would have gotten zero, nada, zilch. They would have been left out.
And they probably wouldn't have been very happy about that.
They would not be happy. And you have to keep in mind, if you and I both died, maybe we're in a car wreck together. I died at the scene. You died on the way to the hospital. So there may not have been any time for you to do anything about it.
This is true.
It's not that you were an evil stepmother. You just had the audacity to live longer.
How rude.
How rude.
And that makes perfect sense, though, if you think about it. And the state size, but I don't know. That is kind of messed up because, obviously we would be partners and we both have kids. It doesn't seem fair that your kids would get left out just because you died first.
Well, it doesn't. But in effect, by putting everything in both names, as I described, we in effect are doing estate planning. It's just we don't know it.
Oh.
See, when you and I chose to put the house in both names, and let's say it was my house from before, and I owned it free and clear, but I didn't want to have you thrown out just because I died, so I put your name on the house. And that's very common. I mean, most husbands and wives put the house in both names. Most husbands and wives have joint checking accounts, savings accounts, etc. Life insurance policies are the same way. Now, life insurance you actually have a little control over because if I have a life insurance policy and I put your name on as the primary beneficiary, but you don't survive, then My children could be named second, so we could control that by contract in a life insurance context.
Wow. And it's not something anyone would ever really think of. I mean, it's not like people walk around knowing the Kansas law. Obviously you do, but I wouldn't have a clue.
Yeah. Well, that's my job.
That's your job. That's why you get paid the big bucks. Okay, so what does it mean to go through probate, and how can one avoid probate?
Okay. Well, probate is a process, and it's gotten kind of a bad rap. When somebody says, oh, we had to go through probate, then most people would assume, oh my gosh, that means real expensive and a long time. And sometimes it is expensive, and sometimes it is a long time. That's not normally true. It doesn't have to be true. In the old days, when I first started practicing law, most lawyers were taking probate cases on a percentage basis. So you would get a percentage of the estate. Most lawyers today do that same work, but they do it on an hourly basis, so they're just charging for whatever it takes. And in my tenure as a lawyer, I've had times when I had it on a percentage because that's what somebody wanted, and it was a really bad deal for me. And I've had times when it was a really good deal for me, where if you're just charging for time, hopefully it's fair to both sides. That tends to be true today. Most lawyers are doing probate on an hourly rate, so everybody just pays for whatever they need. Probate does not have to be a long time. We have probate cases over today. We can get them over in probably about as short as 9 months, maybe even a little less than that. They don't have to go on for years and years. Now, sometimes heirs get to fighting with one another. Sometimes you have an asset that's very difficult to deal with for some reason or another. And so sometimes it takes longer, but it shouldn't in an ordinary case take a long time. So that's why people want to avoid it, is mostly because it has a bad rap. Now, the ways to avoid it are what I mentioned earlier. So if I wanted to avoid probate and I wanted to make sure that you had everything in this theoretical marriage a little bit ago, all I have to do is write what I call a poor man's will. So the poor man's will is, I don't write a real will. Instead, I put your name on the house, I put your name on the bank accounts, I put your name on any stock investments that I have. I transfer on death. It's called TOD, some people call it, or POD, payable on death. So you can do that with bank accounts, stock certificates, and real estate. So I just take everything and do that with it. Now, the problem with that is, for example, let's say that I wanted to be sure that my children got the farm, because your family doesn't really care about the farm. The farm came from my side of the family. So what I do is I write a transfer on death deed so that my children get the farm on my death. Now, the way that works is, until my death, I can do anything I want. I can borrow money against the farm. I can sell it. I can revoke the TOD. I can give the farm away. I could give it to you, for example. So the transfer on death deed doesn't stop me from doing other lifetime things that I might want to do, but it does take the farm out of probate. So by using transfer on death, payable on death accounts, joint tenancy accounts, joint tenancy on real estate, that poor man's will can avoid probate. The problem is, usually people forget things. I've got one right now where we thought we had gotten everything in both names, and we've got one asset left that was forgotten. And unfortunately, it's too big to use any. There are some alternative processes if the asset isn't too large, but in this case, we're actually going to have to probate a will because we forgot one thing. And when I say we, it's really the person who owned it forgot they owned it. It's just something they forgot about when we were doing the estate planning, and that's unfortunate because the probate process is end up going to take just as long, cost just as much money as if most of the other assets were in there too. So that's another reason that it's important to do the planning process, is because most people forget stuff. That's very common.
This is true. All right, so the next one is, what is the difference between a living trust and a will?
Okay. When I went to law school in the last century, literally. But when I went to law school, what we think of as a living trust today would be pretty hard to have done effectively, maybe even impossible. But a living trust is basically a contract, and typically what we think of as a living trust is I write a trust for me, and I appoint myself as the trustee, which means the person who's going to manage the assets. I also make myself the beneficiary, so that if I want any of the assets that are in the trust, I can take them and I can use them just like they were my own, because in effect they are. So, for example, back to the family farm. I put the family farm in a living trust. While I'm alive, I treat it just like it was my own because I'm the trustee. And then on my death, I write into the trust what I want to have happen. And in this case, maybe I want my children to have it rather than you or your children. So it is a way of bypassing probate, because a trust does not go through probate. So in effect, by contract, I've appointed a successor trustee to myself. Might be you, might be anybody. And the successor trustee is directed that upon my death, of course, I'm not around to control anything anymore, so the successor trustee is then directed perhaps to sell the farm or divide the farm up and give it to my children, whatever it is that I want to have happen after my death. So a living trust is a way of controlling assets just like a will would, because I could do all of that same stuff with a will, except it would have to go through probate if I had a will. And I can do that without going through probate. So I die a month later, the trustee deeds the farm out to the kids, and there's no probate then.
Gotcha. So while we're on that subject, I've seen this happen before, and I know that you have, whenever people have assigned power of attorney, but they haven't written it the right way. So it expires upon their death, and they thought that this power of attorney carries through, and now all of a sudden there's nothing. How can they prevent that?
Well, that's a really good point. Power of attorney is a legal instrument that gives one person, so let's say I write a power of attorney and I give you the power to do what I can do. Now, a general power of attorney gives you the power to do anything I can do. So that means you can buy and sell real estate, you can borrow money, buy and sell stocks, pay bills, you can do anything I can do. If a power of attorney is used between a husband and wife, and it is quite common, and we would usually do a power of attorney between a husband and wife, particularly once people are past maybe 65, primarily because we're concerned that one person or the other might end up with a disability that would prevent them from taking care of business. So, for example, I give you a power of attorney, a general power of attorney, and then I get dementia, so I can't take care of business anymore. Well, I've got a retirement plan that has some options or rights that might be exercised. Well, if I have dementia, I can't do that. But if you have a power of attorney, then you can do it for me. So it's part of a typical estate plan. I don't necessarily urge people to do a power of attorney when they're younger, but the more advanced in age you become, the more concerned you become with a power of attorney. Or if you have somebody contract a debilitating disease, so in the early stages, say, of ALS, we might have someone give a power of attorney to their spouse, even though they're not very old, because we know that ALS will progress. And eventually this person is not going to be able to take care of business. So we go ahead and do a power of attorney so that the other spouse can. Now, I've talked about it in terms of a spouse. We also use them in the case of children. So when you have an older parent who we're concerned may become debilitated, it would be very common to give a power of attorney to a child then. Now, the problem becomes, is the power of attorney properly drawn? And Kansas has some very odd rules, odd in the sense that they surprise people. And so if you go out on the internet and find a power of attorney that's a perfectly fine general power of attorney, but because it's not drawn by a lawyer worrying about Kansas law, it doesn't have some Kansas-specific stuff in it, then it doesn't work. So, for example, a power of attorney that I give you that's a general power of attorney, but it does not say In the real estate section, when it talks about I'm giving you the power to do everything, including real estate, it doesn't say including the homestead. Then under Kansas law, you can't deal with the homestead because the homestead in Kansas is a very protected right. And there's courts that have said if you don't say homestead, then it doesn't include the homestead. And that's a kind of a somewhat common mistake. Now, this is largely driven by the title company. So, I've got dementia. I'm in a care facility. You don't want to live out on the 80 acres anymore. You want to sell the house and come to town. But it doesn't say the homestead. So you're kind of stuck. The only way for you to get rid of the 80 acres is to probably go through the process of getting a guardian conservatorship appointed for me so that you can handle the homestead under the guardian conservatorship because the power of attorney is not broad enough to allow you to do that. So that's one of the areas where mistakes get made when people use the generic documents that you can find out on the internet.
Right. So don't practice law unless you know what you're doing.
Well, that would be true.
We're going to have a quick break from a word from our sponsors. Thanks for listening to Real Estate 101, and I'll be back with Vern in just a few.
When someone has a passion for what they do, it comes through in the product they provide their customers. Just ask LaRocco's Pizza's new owner, Jason Johnson, about their crust. They make it every day and let it rise for a minimum of 24 hours before they use it for their pizza. And his staff doesn't want to do anything they won't be the best at, and you can taste it in their pizza. LaRocco's Pizza, just a half block north of the I-470 and Gage Boulevard exit. Come taste the difference.
Thanks for joining us again. This is Carrie Brown with eXp Realty, and I'm back with Vern Jarboe. And Vern is with Sloan Law Firm here in Topeka, and we've been talking about wills, estates, and trusts. So we're going to just dive back in because there's a lot of things to cover. When it comes to setting up an estate, when is a good time to get started?
Well, I believe that anybody that has a child should think about estate planning. We talked earlier about the fact that if you don't do estate planning when you have children, you're putting a judge, and you don't know which judge, in the position of having to decide who your children will live with and how they should be taken care of. The other thing we worry about with children is when a child turns 18, they will be entitled to their inheritance unless you've done something different in your estate planning. And for most people, the idea that you give an 18-year-old any significant amount of money just doesn't sound like a good idea because most of us can think back to when we ourselves were 18 and think about what we might have done with a pile of money. So in a kind of an extreme example, I had a client some years ago who was made quite wealthy by his father's untimely and early death. But the father had the common sense to go ahead and do some estate planning early. And so the kid got a significant sum of money when he was 18, a little bit more money when he was 21, a little bit more money when he was 25, a little bit more money when he was 30. I think he got a sizable amount when he was 35, but I was talking to him when he was 40, and he was getting a real significant, the balance of the estate at that point. And, he and I were just visiting about that, and he was telling me about the poor judgments he made when he was 18 and 21 and 25, and how the chunks of money, and they were significant chunks of money, any of us would have been happy to have received, but how those chunks of money, even as large as they were, just didn't last very long because he didn't have any frame of reference for what it meant to get money and keep money. Finally, as he got a little older and he got more money, he had been able to see the pattern, and the pattern was that as soon as he got it, he blew it. And so as he got a little older, he was able then to say, I should do something more permanent with my investments. And he bought a business, which he ran successfully for many decades here in Topeka. But the point of the story really had to do with how smart his dad was to have spread the money out and let him learn. Now, most of us would have thought that it was a very expensive lesson because of how much money he walked through in those early years, and it was a lot. But on the other hand, some lessons have to be learned that way. You can't go to college and learn that lesson. It doesn't mean anything until you've actually lost something of your own. And that's how this young man And, by the time I was dealing with him, he was 50, so he wasn't a young man. But that's how this guy had really learned hard lessons of life, and they were very expensive lessons. But he learned them because his dad distributed the money over time. Had the father not written a will, the young man would have gotten the whole thing when he was 18. And since he lost everything he had when he was 18, he might have been, on the streets after that, for all we know. But children then bring two consequences. One is, who are we going to have take care of them physically? Where are they going to live? How are we going to take care of their bills and expenses? And then secondarily, when do we think they're old enough to manage whatever it is we're going to leave them? And that is, of course, a real problem. Sometimes we have children who come out of 18 years old and they would be fine no matter what you gave them. And sometimes we have children who are 40 and still can't manage money. And part of it, of course, is realizing as a parent that you can only do what you can do. And so you do the best you can to plan, and you have to hope.
Which makes sense. I mean, you think about it.
Yeah.
I mean, even at our age, I don't know about you, but I don't have it all down.
Nope.
So you always make mistakes. But imagine 18 years old, I totally would have messed stuff up. So, and I feel like I was pretty responsible at that age. So, okay, so what are the most common things that they should get in order before they come in and, say, meet with you to start going through this process?
Well, in days gone by, I probably would have told somebody that they needed to have more or less a financial balance sheet together before we got together, because at that time, when I first started practicing law, the federal estate tax began at really low levels. And most people ended up paying federal estate tax. Today, the federal estate tax is really almost no one pays it. It's just reversed to what it used to be. So today, I don't tell people I really need a financial statement to have a good conversation at the first meeting. Usually we have kind of a basic conversation about some of the same things that we've talked about here, and I'll talk to them a bit about how the federal estate tax and other tax laws work. We talk a little bit about gifting, because there is always the opportunity to give things away during your life. And most people learn along the way someplace that, there's an exemption. You can give away $3,000 a year. You can give away $10,000 a year. You can give away some other number. And actually, there's a moving target, because Congress has now set it up to where it's not the same all the time. And I just don't even tell people what the number is per year, because it will be different next year. It's easier just to realize a more fundamental thing, which is, unless you're going to give away more than $5 million, it really doesn't matter. And you think about the number of people in Topeka, in the entire city, who could give away $5 million to one child, and that would be a pretty select group of folks. Not that there's no one, but because there are, but it's just not your everyday person has to worry about that. So these numbers, in terms of what can you give away without owing estate tax, that has gone by the way pretty much. If people want to give things away because they want to give things away, then that's something that we think about. But in terms of doing it for tax planning purposes, we don't anymore. So today, having things in order, it really isn't a problem. I mean, I would tell you, well, do you know the names of your kids? Do you know how old they are? Do you know where they live? Know who you're married to? And do you have a general idea what you own? And at that point, we can have a very meaningful first conversation to talk about what your objectives are. And then you might be tasked with gathering more information, or I might be tasked with preparing an outline of what we're going to do.
I know for us, and I know that we've probably talked about this on an earlier show, but Troy and I, we like to scuba dive, which isn't always the safest of things to do. And we travel a fair amount, and anytime we've ever left the country, the kids throughout the years, we try to do at least one trip that is just us. So that means we've left our kids. Well, over the years, that's been, how old were they? And if something were to happen to us, what would be the plan? Or if something happened to one of us, what would be the plan? Do you ever give directions to say, okay, the fallback plan? If this should happen, plan A, plan B, and then revise it each time? I mean, it's changed now that they're older, obviously, but when they were younger, we had to look at all the scenarios.
Oh, absolutely. I try really hard to not give direction, but rather to offer choices and say, okay, here are the things you need to think about, and you need to consider exactly those things you just mentioned. What if one of you survives and the other one doesn't? And for how long? I mean, is it that you would do the same thing for 10 years or 20 years? It is conceivable that if you had a fairly ordinary life, you could write a will when you have children that would last you for a very long time. When I had my first child and wrote my first will, actually I had 2 children when I graduated from law school, and I wrote my own will. And that will, even though I'd had a 3rd child after that will was written, that of course I didn't know about, that will was good up until I got divorced, because everything that was in it would have worked okay, even though my children were much older. So it is possible to write one that will last a long time. Now, as you get older, your children are grown, and maybe you're into a second marriage, or maybe your spouse has predeceased you and you find yourself alone, then you probably need to start thinking about looking at your will periodically, and making changes as you need.
We recently had a deal that obviously you saved the day on. The family had used I'm not going to say the wrong attorney. They used the wrong vocation of attorney. They used a criminal attorney to do estate matters, and it didn't get done right. And so obviously I'm like, okay, you got to call Vern. Vern's going to fix this, and Vern did fix it. But when it comes to doing these types of things, getting the right lawyer, it's like getting the right real estate agent, but obviously the right lawyer is important. So coming and just talking, obviously you're a lawyer, so everybody says, oh, well, of course he's going to say that. I can say by watching what this family went through, having the right attorney would have saved them a lot of money, a lot of heartache from the get-go. What is the best thing to know whenever you're interviewing an attorney or picking an attorney to do these matters? What are you looking for?
Well, I think it's fair. Let me say it from my perspective as an attorney. I don't ever mind someone asking me, well, have you ever done this before? How often do you do this? Is this something you do all the time? Or is this something someone else in your firm should do? And, I do have the luxury of being in a good-sized firm, and we have people who do lots of different stuff. We hope we do each piece of it well. But, when I graduated from law school, I was licensed by Kansas to handle a DUI, get you a divorce, form a corporation, help you buy a piece of real estate, and all of that stuff was stuff I was licensed for. It doesn't mean I should have been doing it. So each of us comes to realize with experience the things we like to do, and then we narrow what we do down to those matters. And so for me, I handle just about anything in the real estate area. I have a master's in tax, but I don't sign other people's tax returns because I don't like doing that. Help people organize businesses, and I help with estate planning type stuff. But if you called me because you were in jail, I would say, you need someone else. If you called me and said, well, I'm thinking I might want to think about a divorce, I'd say you need somebody else. So when you're interviewing a lawyer, I think the fairest way to approach it is to say, do you do this regularly? Is this something you do a lot of? Go online and look at their website and see what they tell you they do. And if they spend all of their time talking about the car wrecks they've handled well, that probably means they're not an estate planning lawyer and they're not a real estate lawyer. So just take a look at the website and see what they say they do. They're advertising what they want to do.
Right. Makes perfect sense. Wow. Time went quick.
Are we done already?
We are. We didn't even get all the way through the questions. So we'll definitely have to have you back. Thanks for joining us, Vern. And if you're looking to buy or sell, be sure and check out our website at topekahomeadvisors.com. And we'd be happy to help you if you want to give us a call at 785-213-5188. You can find Vern. Vern, how do they get a hold of you?
Well, the office number is 357-6311. Go to sloanlawfirm.com on the web.
Thanks for joining us. Thanks for listening to Real Estate 101.
Thank you for listening to Real Estate 101 with the Carrie Brown team from Preferred Advisors.